we get started. All right, I've started the live stream. So what I have is Miss Bruner, Angel Bruner. We're going to continue her until tomorrow. Mr. Harris, Justin Harris, he did first appearance yesterday and he had a bond, so we're not going to deal with him today. And Miss Destiny White is going to be continued until tomorrow. Now, Miss Mary, can you hear me?
I can.
We have Miss Cunningham, Sophia Cunningham, but it's also listed as Sophia Cunningham Laird. How is she listed on your calendar? Is it Cunningham?
It's showing her last name is Laird, Sophia Cunningham.
Yeah, on the warrant and on my bond sheet is showing as Cunningham. And because Miss Mary is going along with me, I want to make sure that I put her in whatever order it is on the calendar so she doesn't have to go flipping through the calendar to put the information in.
Well, she's not listed as Cunningham. What's the other one? Laird, L-A-I-R-D?
Yes.
Yeah, she's listed as Laird, L-A-I-R-D.
On your calendar?
On the calendar, yes.
Okay, so I'm going to call her in that order as Laird. All right. Is there anything else that we need to take care of before we get started?
No, Your Honor. In reference to Mr. Grayer, is he going to be last, or do you want him to go in alphabetical order as well?
I'm gonna save him till last. Oh, and that brings up one other thing. Because we have a female fugitive and two male fugitives, do you want to do all the fugitives at the same time?
Yes, Your Honor. It's actually two females and one male.
Two females and one male. Okay.
Yes, Your Honor.
All right. Thank you. Okay, I'm ready to start.
Yes, Your Honor. Thank you.
Okay, good morning, everyone. This is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing. But should you give up this right, anything you say during this proceeding may be used against you. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: to the presumption of innocence, to indictment by a grand jury for most felonies or by accusation for misdemeanors, to a speedy and public trial by jury, to see, hear, and question witnesses who are called to testify against you, to compel the attendance of witnesses to testify on your behalf, to testify on your own behalf or offer evidence in your own defense, and to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. You will also be prohibited from contacting the victim while you are in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise your right hand for me, please. Do you swear or affirm any statements you make during this proceeding shall be the truth, the whole truth, so help you God?
Yes, sir.
Thank you. Thank you. Let's begin with the ladies. I believe we have Miss Alexander.
Yes, Your Honor, she's present.
Okay. Ma'am, you're charged with 1 count of murder, 1 count of aggravated assault with a deadly weapon, and 1 count of armed robbery. I am unable to set bond at this proceeding on these charges. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning. You're going to have a bond hearing date set at a later date because these charges, the bond hearing has to go before a superior court judge.
Okay.
Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, ma'am, you're free to go back.
Johnson. Jasinski, you next.
Okay. Is it Jasinski or Johnson?
Ashley Johnson.
Okay, Ms. Johnson, you're charged with 1 count of giving a false statement. This is a felony offense. Bond is going to be set at $5,000. There's going to be a stay away provision on this bond to stay away from a Deshaun Boyd. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No questions at all.
Okay, ma'am. I'm sorry.
No, you said the bond is $5,000?
Yes, ma'am.
Okay.
You're free to go back.
Okay, thank you.
You're welcome. Miss Jasinski.
Cunningham, you're next.
Miss Jasinski, ma'am, you're charged with 1 count of family violence battery and 1 count of criminal damage to property in the 2nd degree. The criminal damage to property in the 2nd degree is a felony offense. The family violence battery is a misdemeanor. Bond is going to be set at $5,000 for the family violence battery and $5,000 for the criminal damage to property in the 2nd degree. There's going to be a stay away provision on this bond to stay away from a Jakari Odom. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes.
You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
So $10,000 together for the whole bond.
Yes, ma'am.
Okay, thank you.
You're welcome. You're free to go back.
Cunningham,
Okay.
Odom, you're next.
All right. So, and ma'am, is your true and correct last name Laird?
No, I'm divorced. It's Cunningham.
Okay. Ms. Cunningham, ma'am, you're charged with one count of simple battery. Bond is going to be set at $5,000. This is a misdemeanor offense. I did not place a stay away provision on this bond because the victim is your adult son.
Yes,
Does your son live with you?
yes, he does.
Do you believe that you can live in this home without the police being called back out?
Yes,
Okay. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
no,
Okay. Do you have any questions of me?
yes. During the time of the arrest, the arresting officer never read me my Miranda rights. And he said it was video record, so you should be able to see that. My Miranda rights was not read to me. He said, you're going to jail, and that was it.
Okay, so it's commonly misunderstood that Miranda rights have to be read. Miranda rights have to be read if law enforcement intends to use any statements that you may have made against you. Okay, so and that applies to custodial questioning. So if an officer arrives on the scene and you say, I did it, officer doesn't have to read you Miranda rights. But if you're a suspect and they believe that you did it, that may be something that your rights have to be read. But that's a discussion that's better had between you and your lawyer. And with there being body cam footage, that'll tell the day. However, in cases like this, where there's a complaining witness, if the complaining witness says she did it, that's enough. You can say, I didn't do it all day. And the person said you did it and you still could be convicted. Okay?
Understood.
Okay, ma'am, you're free to go back.
Thank you.
You're welcome. Miss Odom,
Salgado, you're next.
ma'am, you're charged with one count of battery. I'm going to set your bond at $2,500. I'm going to place a stay away provision on this bond, stay away from Mr. Ansel Claiborne Toric Johnson. Do you understand that, ma'am?
I understand.
Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? You do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. Thank you.
Okay, you're free to go back. Miss Salgado. Miss Salgado, ma'am, you're charged with one count of simple battery. I've set the bond at $5,000. There's going to be a stay away provision on this bond, a stay away from an Axel Nava. Do you understand that? Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer? Okay. Do you have any questions of me?
Yes.
Go ahead.
My question is, when I call police, I call because he's aggressive with me, and I have broom in my hand, and he lying to the police. I don't know. He have a report with my little girl, and he trying to squeeze her, and
Miss,
Any questions about
ma'am,
this?
yeah,
Yes.
you don't want to discuss the facts of your case. It's best to have that discussion with your lawyer. The thing that most people don't understand is when you call law enforcement to your home, they have an independent duty to investigate the case and make whatever decision they seem to be right. And a lot of times people call thinking they're right when they're actually in the wrong. And if the law enforcement officer determined that you were in the wrong and they made the arrest, they made the arrest. But the state has to prove your guilt beyond a reasonable doubt. So they still have to prove that you are guilty of this offense. Okay? All right. You're free to go back, ma'am. Okay.
Robin. And the other one, Nate. Come on.
Nate, yes.
You don't need that.
I'm gonna write down.
Okay, let's see.
All
All right, ma'am, can you identify yourself?
Robin Spraggins.
Okay, and you are Miss Nate,
Yes.
and you are Mr. Harris.
Yes, sir.
Okay, so I'm about to tell the three of you something that applies to you all equally, but then I'm gonna go to Miss Spraggins, Miss Nate, and then Mr. Harris as it involves your individual circumstance, okay? So all three of you are here on what are called fugitive from justice warrants. And what that basically means is that there is a warrant for your arrest out of another state. And that law enforcement contacted the other jurisdiction and they said that they do intend to extradite you, meaning they intend to bring you back to their jurisdiction to face whatever charges that are outstanding. You have the same rights and privileges as I discussed earlier with everyone else. But in your situation, you have the right to challenge that warrant. And there are two basic conditions that are challenged in the warrant, whether you are the person named in the warrant and whether the warrant actually is a valid warrant. So if you were to choose to challenge the warrant, sometime between now and the next 90 days, there will be a hearing in Clayton County to determine whether one, you are the person named in the warrant, and two, whether the warrant actually names a charge. If those two conditions are met, then the judge will sign off on it and the requesting jurisdiction will receive notice. At that point, the requesting jurisdiction has 30 days up to 60 days. They can request a 30-day extension to come and extradite you, come and pick you up and take you back to the jurisdiction. If you believe that you are the person that is named in the warrant, and if you believe that the warrant has is valid, you can waive that whole process. And then that 30 to 60-day window begins to run today. If at the end of that 30-day period, you have not, they have not come to get you, Clayton County will call and say, hey, do you still intend to come get this person? And they may say, no, we're not gonna do it. And if that happens, you'll get released out the front door, but the warrant will still be valid. So you can be released out the front door and 5 minutes later, you run into a law enforcement officer. They run your information, they see the warrant is valid, you go back into custody and the process starts all over again. Is everybody with me so far?
Yes, sir.
Okay, so for Ms. Sproggins, the allegation is that you are wanted out of, is it Oskaloosa? Or
Okaloosa.
Okaloosa County Sheriff's Office in Florida. There's a warrant for simple assault. And they're listing it as a felony. And I don't know the laws in Florida, so I'm assuming that that is a felony. For Miss Nate, you are wanted for by Miami-Dade Police Department in Florida for assault. And they're saying it's a felony, and they're saying that they will extradite. I'm sorry, ma'am.
We didn't say that.
We didn't
It was
say that
the
name.
guy.
Okay, I couldn't understand. Miss Nate, did you ask about Florida?
No.
No, it was a guy.
Oh, okay, okay, okay. I'm
Like, dang, all of us wanted out. I just read the paper saying all of us basically wanted out of Florida.
hold on one second, Mr. Harris. It's Escambia County, Florida, and it says a probation violation warrant, and they're saying it's a felony and they will extradite. So what I always encourage everyone is, as soon as possible, to get an attorney in whatever jurisdiction that is requesting you, because especially now during the COVID related times, and everybody's case is different, but some places they don't want to travel. And so if you hire an attorney and your attorney goes and speaks to the prosecuting authority down there, I've had the next day, I've had bonds come back from whatever the last one I think was out of California, where they said, hey, we've made conditions, or we made preparations out here, and release them. And so we released the person because we don't really care about your case or your charges. We're holding you because if we had a person that was in Florida that we wanted to extradite, we would want and expect for the law enforcement authorities in Florida to hold that person until they receive word. So, Ms. Sproggins, do you have any questions about this process? Do you have an idea of what you want to do?
I want to sign and waive that.
Okay. Okay. Ms. Nate, do you have any questions about this process?
No, sir.
Do you know what you want to do?
Yes, sir. I want to sign this waiver.
Okay. Mr. Harris, do you have any questions about this process?
No, sir, I'm gonna sign my waivers.
Okay, so each one of you, when you sign the waivers, they're gonna send the paperwork over to me, and I'm gonna sign it, and then that clock begins to run today. But I do encourage each of you to try to get a lawyer to help assist you in whatever jurisdiction is requesting you, okay?
Yes, sir. All right.
Okay, all right, so I think that ends, you can go off, Mr. Harris. I think that ends on the ladies' side. So ladies, once you sign those, they'll send it over. Is there anything else we need to do on the ladies' side? Okay. Okay, let's switch over to the male side. We're going to begin with Mr. Billingsley. Mr. Billingsley, sir, you're charged with 1 count of murder, 1 count of terroristic threats or acts, 1 count of criminal attempt, 1 count of criminal damage to property in the 2nd degree, 1 count of possession of firearm or weapon during the commission of a crime, and 1 count of aggravated assault. I cannot set bond on the murder and aggravated assault count at this time. and I've denied bond on the other offenses. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're also going to have a bond hearing date set, but that's going to be determined because that also has to go before a Superior Court judge. Would you like for me to appoint you a lawyer?
Yes, sir.
Okay, you do qualify, Mr. Billingsley. I'm going to appoint a lawyer to represent you. Do you have any questions of me, sir?
No, sir.
Okay, you're free to go back.
Bland.
Mr. Bland, sir, you're charged with 1 count of criminal trespass. That's a misdemeanor. Bond is going to be set at $5,000. You're charged with 1 count of aggravated assault on a peace officer. Bond is going to be denied on that offense. And you're also charged with false imprisonment. Bond is also going to be denied on that offense. You're going to, there's going to be a stay away provision on this bond to stay away from a Francis Bland. Do you understand that, sir?
Is this new or is this the old one? Because I have another case with the same charges exactly, and I haven't had anything since then. I haven't been arrested. I've been locked up since.
Okay, when did that happen?
The initial was 5/9, May 5th. I mean May 9th.
Okay, this is from it says 5/8.
I've been in here since 5/9.
Okay.
So the other one that's on 5/11. I've been in here since, and I haven't supposed to no officer at all, and I couldn't trespass or false imprisonment anybody because I'm in here. And then I don't know.
Hold on, Mr. Bland. Hold on. Okay, so all 3 charges stem from 5/8.
Now it's 5/8, which
when you say now, I said 5/8.
So the one you just named is from 5/8?
Yes, sir. The dates for all 3 warrants say on 5/8/2022.
Does it say when it was issued?
It was issued on 5/17 of 2022.
How's that possible?
Because that's when the officer went to get the warrant. So these warrants are not, these are what are called, we call them CWs for short. Stop. Let me explain it to you. And then if you have questions, ask. Okay. So a CW for certain serious offenses, there's a detective assigned. The detective investigates. When the detective believes that they have enough information, they come to a judge and seek a warrant. So I've done warrants for stuff that happened 6 months ago. Okay, so did that answer your question?
Somewhat. Wouldn't I have been arrested on 5/8 then and not on the 9th?
Sir, were you arrested on 5/8?
No, not at all.
When you were arrested on 5/9, where were you arrested? What were the charges?
Those same 3 charges you just named. And those are the only time I've been arrested since last 2020.
Okay, and you were given bond? Hold on, you were given bond?
I had to go to my preliminary that's on the 25th. And that's when I was gonna get a bond for the aggravated assault, the 1. Now it's 3 coming up. And I've only been arrested 1 time within the past 2 years. Period.
Okay. Do you have a lawyer appointed already?
Right now, no.
Do you want to have a lawyer appointed?
I mean, I would like for something to go into motion because I've only been arrested 1 time for those 3 charges.
Mr. Bland, I asked you a real direct question. I would like a real direct answer.
Yes, sir.
All right. See how communication can be effective?
Right.
You did not fill out the form, Mr. Bland. Are you currently employed?
I am.
About how much do you make per?
Well, being here kind of messes with that, but I'm gonna say about $2,000 a month.
Okay,
25.
hold on one second. So it appears that you have already been appointed a lawyer
Mhm.
for those other charges. So what you're saying, Mr. Bland, it rings true to me as a possibility. Okay. What could have happened is that when it got to an investigative stage, they say, you know what, these charges, they're not going to stick. So they may have went and gotten warrants through a judge, and they may be dismissing those other charges and moving forward on these charges.
Can they do that within their right?
Yes, sir. They can. And that's why it is important to have a lawyer as soon as possible, because the lawyer may have found something that was wrong.
Right.
And then they realized that something was wrong and said, these charges are going to get dismissed. We need to go and fix it.
Yeah.
I don't know, but that's where talking to your lawyer, and you may not have, appears like you haven't spoken to anybody. Okay. So what I'm going to do, Mr. Bland, is for today, I'm going to set the preliminary hearing for June 1st, but you indicated that you believe you're going to have a preliminary hearing when?
I have it on the 25th.
25th. Okay. So I'm going to check into this, and if these are the same charges out of the same set of facts, this may be something. Okay. This may get placed on the 25th calendar instead of June 1st.
Okay.
But I've been told that you have a lawyer. And I am going to, let's see. Looks like Judge Bridgewater is going to be conducting the hearings on that date.
But if go ahead, sorry.
Thank you, sir. It looks like Judge Bridgewater is going to be conducting the hearings on that date. Do you have any other questions for me, Mr. Bland?
If on the 25th, if I was to get a bond, would that be everything combined at that point?
Yes, sir.
That's it then.
Okay. All right. You're free to go back.
Thank you.
You're welcome. Mr. Boswell. Mr. Boswell, sir, you're charged with 1 count of murder, 1 count of aggravated assault with a deadly weapon, and 1 count of armed robbery. I cannot set bond on the murder and armed robbery charges at this junction, pursuant to statute 17-6-1. So I'm denying bond as it relates to the aggravated assault charge, and I'm going to allow one judge to just deal with all of this at the same time. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning. That's going to be courtroom 201. Your bond hearing is going to be determined because it has to go before a Superior Court judge in Clayton County. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Boswell. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back. Mr. Burgess. Mr. Burgess, sir, you're charged with 2 driving related offenses. And you're charged with 2 driving related offenses, and these bonds are set by schedule, which means they're automatically set. So for the failure to stop or yield at a stop sign, bond is going to be set at $500. For driving a vehicle without a valid license, bond is going to be set at $1,000. So you're going to have a total bond of $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Burgess. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir. Thank you.
Okay, you're free to go back.
All right.
I'm sorry, tell me those amounts again.
Oh, $500 for the stop sign and $1,000 for the driver's license.
Okay, thank you.
You're welcome. Mr. Butler.
Sir.
Mr. Butler, sir, you're charged with one count of violating Georgia seatbelt law. Bond is going to be set at $500. You're charged with 2 drug-related offenses, possession of more than an ounce of marijuana and possession of marijuana with the intent to distribute. I'm going to deny bond on both of those felony charges at this time. You're also charged with 1 count of use or possession of drug-related objects. Bond is going to be set at $1,500. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to have a bond hearing date set for June 3rd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
You got the paperwork, don't
So
you? Yes, sir. Yes, sir.
you do qualify. I'm going to appoint a lawyer to represent you. You're free to go back.
Wait until he's done with you.
You can go back. Mr. Davis. Mr. Davis, sir, you're charged with 1 count of battery. Bond is set at $5,000. You're charged with 1 count of criminal trespass, damage to property. Bond is set at $5,000. And you're charged with 1 count of hijacking a motor vehicle. I cannot set bond at this stage on that offense. So bond is going to be denied pursuant to statute 17-6-1. There's going to be a stay away provision on this bond, a stay away from a Kendrick Mobley and a Tamika Minor. Do you understand that?
Yes, sir. I got a question for you.
Okay, give me 1 second. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Now, do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Now, what was your question?
I was really finna ask about the bond hearing, but you said it was gonna be June 3rd.
Yes, sir.
All right, thank you so much, Your Honor.
You're welcome. Mr. Harris has been sent back. Yeah, first appearance yesterday. Mr. Henderson. Mr. Henderson, sir, you're charged with 1 count of criminal trespass. This is a misdemeanor. Bond is going to be set at $3,000. There's going to be a stay away provision on the bond to stay away from a Kenyatta Bashan Murphy. Do you understand that, sir?
I gotta stay away from her.
Yes, sir.
That's my wife.
She's an alleged victim also.
So we stay together. So how do that gonna work?
As long as she's at that house, you cannot go back.
Okay.
Or you're gonna face felony aggravated stalking and your bond will be denied and you'll sit in jail until this case is resolved.
So I gotta stay away from till the case is over with?
Unless there's a change or modification of the bond condition, which can happen, but that'll happen either through a hearing process or through the Solicitor General's office making a request for the bond to be changed, or I'm sorry, the condition to be modified.
Okay.
Okay, and just so you understand, we don't know if this was just a little incident or the police got there right before you kill somebody. So we take the approach that the police got there before somebody was killed until we figure out no, and then the conditions are lessened.
Right.
Okay, your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay. I'm going to find that you qualify. Mr. Henderson, I'm going to appoint a lawyer to represent you. Do you have any more questions of me, sir?
Yeah, how do I get a criminal trespass on my own home?
So property can be jointly owned or it can be solely owned. As you said, she's your wife, so there could be an issue of joint property. I don't know. That's where the hearings and all of this stuff come out to flesh that out. If it's joint property and you interfered with her ownership of the property, that could lead to criminal trespass, because the statute, it says knowing or maliciously interferes with the possession or use of the property of another person. So in this instance, the allegation is that you pulled the fuses out of the car and she couldn't use the car. Okay. All right.
How much you sell my bond? 3,000?
Yes, sir.
Okay,
All right. You're free to go back.
thank you.
You're welcome. Mr. Howell. Sir, you're charged with one count of driving on a suspended license. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with possession of a firearm by a convicted felon on first offender probation. I cannot set bond on this offense, so bond is going to be denied pursuant to Georgia statute 17-10-1. You're also charged with driving a vehicle with no tail lights. Bond is going to be set at $500. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah, why can't say violence on first situation?
Okay. Hold on. I'll get to that. Do you want me to see if you qualify for the appointment of a lawyer?
Yeah.
Okay, you do qualify. Under Georgia law, if a person is on probation or parole and that person is arrested on a felony offense or on a misdemeanor offense involving a crime of violence, judge at the first appearance cannot set bond. Doesn't mean you can't get bond tomorrow, but I cannot set bond at this first hearing by law.
What you mean bond tomorrow?
What do you not understand about that?
You still mean I can't get it tomorrow, so why are you saying tomorrow?
So theoretically, your lawyer can contact the district attorney's office and say, hey, this is the warrant. This is the incident. I've spoken with the probation or parole officer. They're okay with him being released on bond. And then if they agree, they'll consent to a bond.
I don't understand if I'm not on probation or I'm not on any probation right now.
Okay.
I'm not on no probation right now. That's what I'm saying. I'm saying.
Do you want me to look again?
Yeah, I don't have no probation.
Okay.
Nothing, no probation at all.
Okay. So it says you have 19 cycle, well, 20 cycles. That means interactions with law enforcement. And the 20th was on May 17th. Your last interaction before then was May 21st of 2020, probation violation related to a charge out of DeKalb County. And that is what I'm seeing as showing. Okay. So do you understand where this is coming from?
Yeah, county.
Okay, so these records can be wrong. I cannot look at the records and disregard what I'm seeing. So that's what I'm saying about if these records are wrong, your lawyer can quickly get this taken care of. Any other questions?
So I need to call DeKalb County. That's wrong.
I'm sorry?
I need to be reaching out to DeKalb County. That's what you're seeing in DeKalb County for probation.
Yes. Anything else?
No.
Okay, you're free to go back. Mr. Jackson. Mr. Jackson, sir, you're charged with one count of simple battery, family violence. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Antiana Jackson. Do you understand that?
Yes.
Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Yes, sir.
Mr. Keith. Mr. Keith, sir, you're charged with one count of obstructing an officer. That's a misdemeanor offense. Bond is going to be set at $2,000. You're also charged with giving a false name, address, or date of birth to a police officer. Bond is also going to be set at $2,000. So you're going to have a total bond of $4,000. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Keith. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Kennebrew.
He just stepped out, Your Honor. Actually, Mr. Mays. Mays.
Okay, what happened to Mr. Kennebrew?
He stepped out to use the restroom.
Okay, okay. Mr. Mays. Mr. Mays, sir, you're charged with one count of violation of Georgia Controlled Substance Act. That is a felony offense. Bond is going to be denied at this point on that charge. You're also charged with driving a vehicle with an expired tag. And the reason I'm denying your bond, Mr. Mays, is because you were arrested last month. And looks like you were on my May 4th preliminary hearing calendar. So getting arrested in 2 months on felony charges, I'm gonna have to deny your bond at this point. You're gonna have, hold on, sir. You're gonna have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. That date, well, You're not gonna bond out. I'm gonna give you a bond hearing date of June 3rd at 8:30 in the morning, courtroom 201. Now, I interrupted you. What did you want to tell me? Okay. Mr. Meadows. Mr. Meadows, sir, you're charged with one count of battery. Bond is set at $5,000. There's going to be a stay away provision on this bond to stay away from Vanessa Meadows. Do you understand that? Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you will receive a new court date in the mail. Would you like me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay. You're free to go back. Mr. Nelson. Mr. Nelson, sir, you're charged with one count of possession of drug-related objects. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with one count of simple possession of a Schedule I narcotic. Bond is going to be set at $3,000. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No.
Okay, sir, you're free to go back.
Your Honor, Mr. Kennebrew is back.
Okay. Mr. Kennebrew.
Yes, sir.
Sir, you are charged with one count of essentially failing to pay your fare at the MARTA. I set the bond at $1,000, which is the lowest amount that I can set for you to be able to go through a bonding company. You're going to have a preliminary hearing date set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
You do qualify, Mr. Kennebrew. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back.
Okay.
Mr. Oliver. Mr. Oliver, sir, you're charged with 4 misdemeanor offenses. The first charge is speeding. Bond is going to be set at $1,000. The second charge is fleeing from a police officer. Bond is going to be set at $2,000. Third charge is improper lane change or failure to maintain lane. Bond is going to be set at $500. And reckless driving, bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay. I can't understand this. Are you currently working or not?
Yes, I'm freelance doing home improvement.
Okay. About how much would you estimate that you make per hour?
About 20 to 25.
Okay. I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, could you tell me my total bond?
Yes, sir. It's going to be $5,000. Okay. All right, sir. You're free to go back. Mr. Patillo.
Yes, sir.
Mr. Patillo, sir, you're charged with one count of possession of or use of drug-related objects. That's a misdemeanor offense. Bond is going to be set at $1,500. And you're also charged with simple possession of a Schedule I narcotic. Bond is going to be set at $3,000. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify. Mr. Patillo, I'm going to appoint a lawyer to represent you. Do you have any questions of me?
I do. My first question is, one, I wasn't Mirandized, or however you enunciate it. And my second statement is that the police officer asked, can he search my bag? I allowed him to search my purses, but I did not allow him to search my bag. And I'm trying to figure out the object of whomever, what he's speaking of whatever he's speaking of, was a broken glass. And it was a demonstration according to my business. So I wasn't aware that there was residue in it. But I was explaining to him that I was just using it as a demonstration. It wasn't used for to be used at that moment. And at that time, I guess he just wasn't listening, and he called for backup and things in that nature. But I cooperated with them to show them that I wasn't against what was going on. But at the same token, I just got off work. I was working and demonstrating my, you know what I mean? So I'm
gonna stop you before you get too deep into it. Because this is being recorded. That is a discussion that you should have with your lawyer, because based upon what it sounds like, this may be something where these charges go away. I have to explain to people a lot of times, everybody who's had their charges dismissed and everybody who's gone to trial and who's been acquitted, they've gone through this process.
Yes, sir.
So you're presumed innocent right here. They should have a body cam that recorded the whole thing, and your lawyer will request that, and your lawyer will review it with the DA's office.
Okay, so I know together, how much is the amount for bond?
$4,500.
Okay, and when do I get to speak to a court-appointed lawyer?
I don't know. Which I normally tell people, I don't work for them. Correct. So, and they don't work for me. So I don't control their schedule and they don't control my schedule. But I generally tell people, but today is Wednesday. If you haven't heard from anyone by Friday,
okay,
I would call right now your case. Wait a minute. You were arrested with 3 other people, right?
Correct.
So there's going to be issues related to the case being conflicted out, because the public defender's office can't represent everybody. So each one of you are entitled to your own lawyer. So those lawyers will have to get appointed.
I'll have a letter written up and stated exactly what I wrote and stated to you, except for everybody entire and their own lawyers on behalf of me and my business. But at that time, that is for my lawyer and their lawyers, and when we go to court.
Okay.
No problem. And
okay, you're free to go back.
All right.
Mr. Perkins.
Yes.
Mr. Perkins, sir, you're charged with 1 count of misdemeanor shoplifting. Bond is going to be set at $2,000. You're also charged with 1 count of obstruction of a law enforcement officer. Bond is also going to be set at $2,000 for a total bond of $4,000. You're going to have a preliminary hearing date set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail. You did not fill out the form, so do you plan on hiring your own lawyer?
I guess.
Okay.
Yeah, I'll plan on hiring my own lawyer.
Okay, would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
Are you currently working, Mr. Perkins?
quick because I'm hearing voices every day. I'm hearing voices. It's been like 2 or 3 years. I've been hearing voices straight.
Okay.
Now
Are you currently taking any medication?
no, because when I was taking it, it made me commit suicide. It made me took all my pills.
Okay. I am going to appoint a lawyer to represent you. And make sure you tell the lawyer what you just told me, okay?
Okay.
All right. You're free to go back.
All right. Now it's the medical.
Mr. Ross? Mr. Ross, sir, you're charged with one count of theft by shoplifting as a misdemeanor and one count of violation of Georgia Controlled Substance Act. That's a felony offense and you're showing as being either on probation or parole. So I can't set a bond at this time on a felony offense. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing date set for June 3rd at 8:30 in the morning, courtroom 201. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, please.
You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Why wouldn't you just set it where the county could come get me?
I can't set a bond. It would be against the law for me to set a bond at this hearing on this felony offense, knowing that you're on probation. I can't just follow the law when I want to follow it and don't follow it when I don't.
You could set a bond at the next one?
So yes, the short answer to that is yes. But between now and the next hearing, let's say you talk to your lawyer, you say, hey, look, I want to waive this over to Superior Court and they can consent, I'll consent to a bond. If they'll consent to a bond, my probation officer come get me and take me back down to Spalding County. So all of that stuff can happen, but you're going to have that discussion with your lawyer.
And you're going to give me a lawyer, possibly?
Yes, sir. I've appointed a lawyer to represent you.
Okay. And I'm going to speak to that lawyer before the court date?
Yes. You're being appointed the public defender's office. And there, I think at least now 5 lawyers that are in rotation for people for preliminary hearings. And so they will, my understanding of their process now is that they schedule appointments to be able to speak to you over the phone.
Okay.
All right. So if you get that notification, accept the appointment offer, because that's something that I've seen as I come into preliminary hearings where they're trying to speak to their client and the client don't want to speak to them. But yes, all of that stuff can happen.
All right.
Okay. Mr. Gerald Wheeler. Mr. Wheeler, sir, you're charged with 1 count of possession of marijuana less than an ounce. That's a misdemeanor offense. Bond is going to be set at $1,500. You're also charged with violation of Georgia Controlled Substance Act, possession of a Schedule II narcotic. I cannot set bond for that offense at this stage pursuant to 1710-1 because there's a showing that you are on parole. And it looks like they're saying that there's a hold on you from the parole board, that they apparently have a warrant for your arrest. And you're charged finally with giving a false name, address, and date of birth, and bond is going to be set at $2,000. Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing set for June 3rd at 8:30 in the morning, courtroom 201. You didn't fill out your form. Does that mean you're going to hire your own lawyer?
Yeah, they gonna be in.
Okay, do you have any questions of me?
Oh, no,
Because-
no, listen, I had a Percocet, and you see my hand right here, I hurt my hand. You see it's still swollen.
Uh-huh.
Like, I don't be carrying around a whole bottle of Percocets. So I probably had like 2 Percocets because I wasn't gonna be out that long. So when I got stopped, he asked me what it was. I told him that, you feel me, it's Percocet. Then I showed him my prescription over the phone though, and he still charged me with that though. As you see, I hurt my hand in a car wreck, and that's what he prescribed me for. So like, how that work? Like, he still charged me for something that y'all gave me though. The pharmacy gave me that.
Oh, I was gonna say y'all. I'm like, I ain't no doctor.
Y'all work together.
So, Mr. Wheeler, that is something that may lead to this charge being dismissed. However, if you have anything like hydrocodone, Percocet, all of that kind of stuff, keep the pill bottle with you.
I mean, like, I'm not gonna ride around with a bottle full of pills. Like, I wasn't doing that, but going somewhere with my brother to pick somebody up. And
I understand. I'm just saying, if you want to avoid these issues, keep the pill bottle with you. If you want to go through this kind of stuff, don't take it with you. It's your life. You get to live it the way you want to live it. Okay. All right.
So basically you said, I got a bond for all my charges except
For the VGCSA. And because there is a warrant for your arrest from the parole board, if I gave you $1 bond, you're going straight down to Jackson.
Oh no, I hadn't already dealt with it. That's what they going through now. Like, I had that warrant situation going on, but like, they fixing it in the computer. Like my family been in contact with parole on my parole officer right now.
Okay. Anything else, Mr. Wheeler?
Nah, I'm straight.
Okay, you're free to go back. Mr. Jason Wheeler. Mr. Jason Wheeler, sir, you're charged with 1 count of driving a vehicle with no taillights. That's a misdemeanor offense. Punishment set at $500. You're charged with 1 count of theft by receiving stolen property, being a firearm. Bond is set at $2,000, but that was set by schedule. You're charged with possession of firearm by a convicted felon. Denying bond on that charge at this stage. You're going to have a preliminary hearing date set for June 1st at 8:30 in the morning, courtroom 201. You're going to also have a bond hearing set for June 3rd at 8:30 in the morning, courtroom 201. Do you want me to see if you qualify for the appointment of a lawyer? Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Williams. We have Darian Williams. Are you Darian Williams?
Yes, sir.
Sir, you're charged with 1 count of possession of marijuana less than an ounce. This is a misdemeanor offense. Bond is going to be set at $1,500. Your preliminary hearing date is going to be set for May 31st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll receive a new court date in the mail.
All right.
I'm sorry. Would you like for me to see if you qualify for the appointment of a lawyer?
Yeah.
About how much do you make per hour?
I made 18.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir. So,
Okay.
So
Yes.
Oh, I was just saying, so the bond that you just said, I could just pay that today and probably get out, huh?
Yes, sir. This has been set by schedule, which means it's already in the system. So you theoretically could have bonded out before you even saw me.
Oh, for real?
Yes, sir.
All right.
All right, you're free to go back.
And I'm on.
Mr. Rayshard Wilson. I'm doing well. Can we cut the crosstalk? Mr. Wilson, sir, you're charged with 1 count of criminal trespass. That's a misdemeanor offense, bond is set at $3,000. You're also charged with 1 count of aggravated assault. Bond is going to be set at $10,000. There's going to be a stay away provision on the bond to stay away from a Shelley Wilson and a Larry Denham. Do you understand that?
Okay, yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning, courtroom 201. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir. What was my total bond again? I'm sorry.
13,000.
13,000. Okay, what else want to ask you? I talked to my mom and she said that she was trying to talk to someone to get those charges probably dropped because it was like this family dispute.
So she'll need to speak to someone in the DA's office. And it's not necessarily that the charges will get dropped. Because I tell people, once you bring a third party in, that third party now has to make a decision about your life. If it's just a family dispute, the police shouldn't be called. And I'll tell you why. At the time that the police are at your house, there was someone that had a gun stuck in their face, and they really needed that officer to be with them rather than at your house.
Yes, sir.
Okay. Any other questions?
No, sir.
Okay, you're free to go back. Mr. Yarborough.
Yes, sir.
Mr. Yarborough, sir, you're charged with 1 count of aggravated assault. Bond is going to be denied at this time on this offense. There's going to be a stay away provision on this bond, a stay away from a Marcus Owens. Do you understand that?
Yes, sir.
Your preliminary hearing date is going to be set for June 1st at 8:30 in the morning. You're going to have a bond hearing date set for June 3rd at 8:30 in the morning. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
I'm going to find that you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, sir.
Okay, you're free to go back. Mr. Grayer.
Yes, sir.
Mr. Grayer, sir, you're charged with 1 count of criminal trespass. Bond is going to be set at $4,000. There's going to be a stay away provision on this bond to stay away from a Gloria Okohinsi. Do you understand that?
Yes, sir. That's my mother.
I understand. But she's also the alleged victim in this case.
No, she's not the victim. Shh, don't argue with it.
Okay.
So I'm gonna tell the truth. I just got. Did you get a police report? Did you read the police report?
Mr. Grayer, I want you to listen, okay?
Yes, sir. It was regarding with apartments, not my mother, sir. My mother, no, I mean, I never got a police report. I'm not even in the system at this jail, sir.
Mr. Grayer, you said you're gonna listen and then you started talking. All right. So it says that you committed the offense of criminal trespass when you got in an argument with Gloria Okohinsi. The victim walked in her room and closed the door to avoid you. Said you used your foot to kick the door in, causing damage to the door less than $500. So the allegation of criminal trespass is that you kicked in her door, causing damage to her door. And that's where criminal trespass comes from. So you're going to have to stay away from her. If you do not, you're going to get charged with aggravated stalking, which is a felony offense. Your bond will be revoked and you will remain in jail until your trial. You're gonna have a preliminary hearing date of May 31st at 8:30 in the morning, courtroom 201. I am going to appoint a lawyer to represent you. And unless he has any questions related to these charges, he is free to go back.
Yes, I have.
Yes, sir.
Can you hear me, sir?
Yes, sir.
I have a question like so as soon as what if I'm not able to afford the bond, so I'm not working or anything right now? Is there any way I can talk to a lawyer to get probation or anything?
I've appointed you a lawyer, and you will be able to speak to that lawyer. And depending on the facts and circumstances of your case, these charges may be dismissed or it may go to trial. I don't know, but that's where the lawyer comes in.
Yes, sir.
All right. You go back, Mr. Grayer.
Thank you.
You're welcome. Okay, so that completes the calendar. I'm going to do the continuance orders for those two young ladies, and we'll just make certain they come back tomorrow.
Yes, Your Honor.
Thank you. Have a good day.
You too.